Commissions in the matter of International Game Technology PS and others, Camelot UK Lotteries Ltd and matter and the Gambling Commissions and others.
Thank you very much. Yes, good morning. Thank you very much for your submissions, which are excellent. We have read them. We have a lively appreciation of the issues. What we envisaged was dividing up the time roughly so that each of you had about 30 minutes across the piece. At any event, we need to finish by 1, so we can give you the answer by 2. And so that's the broad timetable. There is, however, an exception to that good start, and that is the, to us, surprising issues about the cross-undertakings. And can we be clear? We can spend some time arguing about it if we can, but that will come out of your time. But can we be clear about this? In these cases, cross-undertakings are given. They are a given, and they are given. They are given in writing. And they should be given by those who understand the business that is the subject of the cross-undertakings. And they should be agreed. That ought to have happened, in our view, weeks ago. And it is important. And it's important for this reason. We understand that we're here today to argue about permission to appeal. But we understand the position of the applicants, namely Camelot and IGT, that they also want to extend the suspension. If they don't, then of course we don't need to worry about the undertakings, and we can or not grant permission to appeal, but we wouldn't suspend the time for entering into the contract. That would go, and the Commission would be entitled to enter into the contract. We don't imagine that's what Camelot want, but if that's right, there has to be proper cross-undertakings so as to address the question of the suspension. And we would say, test it this way: if the boot was on the other foot this morning, that Camelot had been successful in front of the judge and got the suspension, and the Commission were here seeking permission, the Commission would have at least the advantage of the undertakings, which would have had to have been given for the suspension to have been granted by the judge. So Camelot can't be in a better position, because they lost in front of the judge, in front of this court. Okay, so it's going to be important, because if we were minded to grant permission, it could only be on condition that we were satisfied with the nature of the undertakings given. So that is at the moment the slightly odd thing about this case. Everything else, so it seems to us, is in apple pie order.
Yes. Well, perhaps if I could clarify our position vis-à-vis the undertaking. There has been some mudding of the waters on the other side, but from our perspective, we did offer a clear and unlimited...
There's no written undertaking, Mr. Coppell. So can we skip the jury points? Can we just focus on the ordinary position in law? Okay? There has been no written undertaking. It is not good enough, no matter how eminent the counsel, to rely on undertakings given by a barrister in court. It's just not good enough. And there's argument about what those undertakings mean, and we see that.
Yes. Perhaps I can put it this way, my lord. The judge dealt with this matter by saying that were she minded to maintain the suspension, she would require as a condition of that an undertaking be given in the usual terms, and we are content for this court to deal with it in exactly the same manner. And
yes, we're not, because, as well, for the reason I've just put to you, that puts you in a better position because you lost.
Just help me dictate what are the usual terms. My pen is poised.
The usual terms are to the effect that should.
Can we ignore the words "to the effect that"? I'm sorry. The usual. I mean, this is the point. It's not. Sorry, I put you on the spot, perhaps unfairly. Somebody should have committed a form of undertaking to writing, dealing with the question of whether it extends to the consequences of delay, whether it extends how much it extends to, both in terms of Olwyn's, if I can put it, own profits, loss or damage which it may sustain. If there's a delay, it ought to deal with the question that's been raised in the correspondence, if it's correct that it should extend to any good causes, as that might be defined. There are all sorts of issues, wrinkles that are out there. That's why somebody needs to put it in writing so we can all see it, and it can be commented on by those who actually understand exactly how the business works. And your side is in pole position to put forward an undertaking that it's prepared to give on the basis of knowing how the business works.
Yes. So, how would my lords wish to address the issue of an undertaking in writing? I can arrange for.
There are lots of people in court who will presumably have given some thought as to what the undertaking should look like because they've been corresponding about it. So I suggest that pretty rapidly one or two of them set to and get on with it.
Yes. So I can. We'll have to check back in the correspondence to see what was said as to the terms of any undertaking. But I can arrange for us to commit to writing the undertaking which Lord Panic intended to convey.
Well, with all due respect to him, forget Lord Panic for a second. What's the one you want to give as a condition of getting permission that you're about to ask for?
Yes.
I mean, let's forget Lord Panic for a second. That was then.
Yes.
What's the undertaking now? What's it look like?
Yes. So the undertaking, and I don't have the usual form of words in my head, but the undertaking would be to compensate the Commission and Olwyn for losses they may suffer as a result of delay caused by the appeal. Now,
it's caused by the suspension.
Caused by the suspension pending, caused by the stay on the judge's order pending the appeal. I'm not trying to.
No, I get the drift, but that's why it needs to be set out, I think.
May I have a very quick word with my learned friends? It may assist, just as a suggestion.
So it is loss occasioned by the suspension pending the outcome of the appeal. Now, my lord,
it is or it isn't.
I'm sorry, Lord.
It is or it isn't. It is caused by the suspension.
Yes.
And just in relation to the appeal?
Well, yes. If the
So, what date do we say the undertaking kicks in?
well, it kicks in from when it is given, and from when it will be.
So, does that mean
in the order of the
Lord
courts.
Panic? Does that mean today?
Well,
I mean, we shouldn't have to be asking these questions. There are an awful lot of people in court. Undertakings in these sorts of cases are standard. We shouldn't be having this debate. but we make it clear that we couldn't possibly extend the suspension beyond tomorrow unless there was a written undertaking in terms that the parties are agreed, effectively, because, or at the very least, we are happy with, although we would then, there's the risk we'd have to then consider submissions about it.
Yes.
It is not a way to run a railway.
Well, it is clearly understood that the court will require an undertaking in writing which covers the losses of the Commission and Allwyn in the appropriate way.
No, I mean, I have in my mind that the recent correspondence raises just at the very tail end of the letter the question of, quotes, good causes.
Yes.
I think I have in my own mind what I think the answer to that suggestion is,
Yes.
but I'm not going to sort of expose my ignorance or otherwise until somebody else has had a go at it. So you need to explain why, if the undertaking doesn't extend to, if it's limited to losses suffered by the Commission and Allwyn,
Yes. Yes.
we all need to be clear why that is, so that
Yes.
everybody's on the same page.
Yes. Well, that is, as I understand it, and in my experience, the standard form of undertaking is to compensate the defendant and sometimes the interested party for losses they may suffer, and losses to good causes. You'll have seen.
Well, I'll expose a little bit of the inner workings. That, as I understand it, good causes are going to continue to receive money because the lottery won't suddenly stop.
Indeed.
It'll just get them from one source rather than another, unless it's suggested that in the hypothesis we're talking about, Allwyn would have generated more for good causes than Camelot would in the intervening period. But that there is a question about whether, if that were right as a matter of fact, whether the undertaking should extend to it in some way, shape or form.
Yes. So, my Lord, it is certainly the Commission's case that there is at least a potential loss to good causes because Allwyn, as fourth licensee, would raise more money. We call that into question with our challenge. But our position in principle is that the standard undertaking, which we've been asked for and would give, is to compensate the Commission and Allwyn for their losses, and losses a lesser amount of good causes is not a loss to the
True,
Commission.
but ex hypothesi this kicks in if you lose. In which case you might be wrong in your first assumption. In other words, it might be demonstrated that indeed Allwyn would generate more for good causes. So ex hypothesi, at least somebody needs to address their mind to that question.
Yes. Well, Lord, I'm content to say that our position up to now has been that a shortfall in money to good causes is not a loss to the Commission or to Allwyn, and that indeed was part of the judge's reasoning on balance of convenience, which we don't challenge.
But an undertaking in a normal injunction case, for example, can apply to losses that may be suffered by non-parties in an appropriate case.
Well, that may be so. Usually, non-parties will come to the court as Allwyn did, and they are joined as a party and will be the subject of the undertaking. But as I say, our position up to now has been clear that we will be undertaking to compensate the Commission and Allwyn for their losses, which is the usual form in this type of proceeding. Well, Lord, at the risk of taking too much time on this question,
Well, only because we've raised it because we think it's very important.
yes.
And it's the only point that isn't covered clearly on both sides in the submissions. So that's why we've raised it.
Well, if I may, I'll come back to it if need be
Fine.
a bit later.
Can I just, on the question of the undertakings, Mr. Moser, as far as your clients are concerned, have they given any undertakings?
No written undertaking or undertaking has been given to date, but we are in the same position as Camelot. My clients are well aware that if permission is given, it would be on the basis of an undertaking, and in which case such an undertaking will be given, or if in the unlikely event that it's not, it will be clear that the appeal cannot proceed.
Well, the appeal can. It's just that there wouldn't be a bar on the Commission entering into the contract with Allwyn, which I suspect is what people are more interested in.
Your Lordship is right.
But if they are, then they need, because the problem is the Linklater's letter said, on any view, therefore, the undertakings don't impact on permission to appeal. Technically, that might be right. But what it does obviously impact on is what the permission to appeal is trying to achieve, which is continuing the suspension of the entering into the contract.
Absolutely, my Lord. And everything your Lordship has said about undertakings is of course, absolutely correct. And it's definitely no surprise, my Lord, to us. And I'm sorry that it's taking up time. My Lord, if it helps, as far as the wording of the undertaking is concerned, slightly unhelpfully, the hard copy of the White Book cross-refers one to an online part of it, at 890 for the actual wording attached to the practice direction.
We have to keep the White Book manageable, Mr. Moser.
Yeah. But, my Lord, the other side's correspondence, which is in the supplementary bundle, gave a form of undertaking, which is broadly, I submit, in the usual form, bar 4 words that I don't recognise. That is in supplementary bundle 2 at page 563.
But I don't think we need to look at it at the moment, because everybody's agreed there should be written undertakings, and everybody's agreed that at the moment there aren't. As I say, it's an important element in what we have to consider. So the sooner written undertakings in an agreed form are provided, the better.
It's understood.
And it's probably not useful to debate now what the wording might include. All right, well, that's helpful. Okay, so, Mr. Cobble, that has taken up some of your time. I'm sorry, but that's the way that it goes. So between you and Mr. Moser, we really need you to have finished within, well, an hour from now, between the two of you.
Thank you, my Lord.
Yeah.
My Lord, the focus of my submissions today will be on persuading the court that there is a real prospect that the full court will find on the familiar test that the judge's decision was wrong by reason of some identifiable flaw in the treatment of the question to be decided, such as a gap in logic, a lack of consistency, or a failure to take account of some material factor which undermined the cogency of her conclusion. And I shall spend the majority of my time seeking to persuade the court that that test from the Sprint Room case, paragraph 76, is met. Before I embark on that task, though, I wanted, by way of background and context, to point to a number of factors which, in our submission, and we've summarised in paragraph 3 of our skeleton argument, make this case a compelling case for the determination of legality to take place before the licence is awarded and not after, in the context of a claim for damages when it will be too late for the position to be rectified. And equally, we say factors which make this a compelling context for the grant of permission to appeal. The first factor is that this is a wholly exceptional public procurement. As my Lord Justice Coulson, I'm sure, will fondly recall, most of these cases are about building maintenance, pathology services, waste disposal, and the like. Important for those involved, but scarcely of national significance. By contrast, the fourth national lottery licence is of enormous significance, both financially to the bidders involved, with anticipated profits running into many hundreds of millions of pounds, but it is of national significance because of the role that the National Lottery plays in national life. Many millions of people play the lottery each week, and the lottery raises billions of pounds for good causes to the benefit of communities up and down the land. Secondly, the outcome of this competition could not have been closer. The scores of the two bidders were so close that any single legal error by the Commission would be sufficient to change the outcome of the competition. We've explained that at paragraph 19 of our skeleton argument. Camelot challenges 4 of the marks awarded to Allwyn, and only one of those challenges needs to succeed to change the outcome of the procurement. Thirdly, the grounds for challenge go directly to the public interest in effective performance of the 4th licence. They focus on the interpretation and the application of criteria which are directed to the risk that Allwyn had substantially overestimated the sums which it could credibly generate for good causes, and the risk that Allwyn would be unable to deliver what it had forecast on the basis of its business plan proposals. And it is accepted, as you know, that the grounds of challenge are at least arguable. Fourthly, the claim is of relatively narrow scope, such that in the judge's view, see paragraph 141 of her judgment, a trial could be commenced 3 months after her judgment. She gave judgment at the end of July, and she held that a trial could be brought on in October. And we had been informed that there was room in the court's diary, indeed, for an expedited October trial. Fifthly, if the suspension is lifted and...
Of course, one sees that, and in these cases there are always arguments about timetables, but that does rather presuppose that the loser accepts the result of the trial, unless, of course, the parties have agreed that they would be bound by the outcome and wouldn't appeal. But that's not, as I understand it, this case. So whilst it's all very interesting that a trial might be done in October, you've got to give the judge time to write the judgment, so that's probably January. Then there'd be questions of permission to appeal. You could well see how it would go well into 2023, even with an October trial.
Well, Lord,
and given what you say about the context, there's also the question, you know, an appeal to this court and then possibly a further stage of appeal. So you, my lord, and I have the great and the good of the procurement bar in front of us. You don't need us to tell you that the trouble with procurement is that the regulations don't really acknowledge the reality of how long it takes to do a trial, for a judgment to be written, for people to consider whether they want to appeal, and so on. So whilst I understand the October trial point, I think you've got better points about the context.
Well, and I really only make the point to highlight that this is not one of those cases which is going to involve numerous legal challenges, tens of thousands of pages of documents.
You say the trial it would be relatively narrow in scope. I follow.
Yes. Fifthly, if the suspension is lifted and the claimants are confined to a remedy in damages, that will crystallise a potential liability on the part of the Commission running to many hundreds of millions of pounds, which, if it materialises, will serve to reduce funds which are otherwise available for good causes. And sixthly, the outcome of a damages trial, if that is what there is to be, will be known before the licence is formally granted on the 1st of February 2024. Again, assuming the suspension is lifted, 4th licence commences 1st of February 2024. There will have been a damages trial and a result. And that creates the risk that the Commission will be granting the licence to a party, and a licence to operate a contract of national significance, which the court, or whom the court, will have found to have been unlawfully appointed. And there was evidence before the judge as to what impact that might have on public confidence in the operation of the National Lottery. Now, these are to some extent unusual and to some extent wholly unique features of this public procurement claim. And taking them together, we say this is clearly a case for a speedy trial which ensures that a lawful appointment is made. And if this isn't that case, we say there will be few procurement claims which qualify for that treatment. Can I then turn to our first round of appeal, which concerns adequacy of damages for the claimants? And I start with adequacy of damages for Camelot UK. Now, the relevant facts for the purposes of this argument are set out in paragraph 81 of the judgment. And the position in this case is, again, unusual in that should the suspension be lifted, the fourth licence awarded to Allwyn, Camelot UK shortly will go out of business as a result of the terms of the third licence, as a result of TUPE to some extent. It will lose all of its staff, largely to Allwyn, and it will lose all of its assets to Allwyn. And it was common ground between the parties that the likely consequence then was that Camelot UK would be wound up once it had finished its obligations under the third licence. Not overnight, it wouldn't happen this month or next month, but it will happen at the end of the third licence, or when Camelot's obligations are fulfilled. Now, against that background, Camelot's primary submission was that damages were inadequate, would be inadequate, because they cannot compensate for the loss of an entire business. That is an irreparable harm, and that damages cannot put a claimant back in the position it would have been in had that irreparable harm not occurred. The principle starts from a case called Lyons, which the judge quoted in paragraph 86 of the judgment. Nothing, the last couple of lines of the extract, nothing can compensate the man for the utter loss of his business by what has been done in that interval, applied by Lord Wilberforce in Garden Cottage Foods and in many other judgments since. And we also showed the judge the extract from Zuckerman that you have, and can I ask you to turn this up, please, in the authorities bundle at tab 19. Zuckerman on civil procedure, principles governing the grant of interim injunctions. And on page 446, the second page of the extract, you have the requirement of irreparable harm. The court is justified in granting an interim injunction only if it is necessary to avoid irreparable harm. Quote from Cyanamid, and then 10.51, although the necessity of establishing irreparable harm as a condition of prejudgment relief is clear, its meaning is far from clear. And then two different types of loss, factually irreparable and legally irreparable harm, are outlined. And on factually irreparable harm, the point is 10.52 Damages will be inadequate where an award would not achieve the object of damages for the applicant. This is where damages would not place the applicant in the same position they would have been in had the respondent not committed the legal wrong to be sought to be restrained. And you have harm which cannot be remedied by damages, into which we say, and we understand Professor Zuckerman agrees, we say the loss of a business, the entire loss of a business, is harm which cannot be remedied by damages. And then you have 10.58, a couple of pages further on, harm which the court is uncertain will be remedied by damages. And that's where you have...
Are any of the cases in the footnote procurement cases?
Sorry.
Any of the cases in the footnotes to this section, procurement cases, or putting the point another way around, I understand the submission, but I think I'm right in saying it's new in the procurement suspension context.
As far as we're aware...
I mean, that's not to say it's a bad point. I'm just exploring. It's not an argument I've heard before, but that, what does that mean? Nothing. But I'm not conscious of it having been an argument advanced in any of the reported cases that I've seen.
It is right that the Lyons principle is not referred to, argued, and that is at least partly explicable by the point that these are very unusual circumstances where there can be no doubt that the claimant will go out of business.
Yeah.
Now, the judge accepted the legal principle, paragraph 87, but she then distinguished it on the fact. So she says in 87, there's no issue as to the principle. If the grant or refusal of interim injunction would put a party out of business, it's likely that no damages would compensate adequately for that, but important to consider the factual context. And then she considers the factual context in paragraph 88, and she says, the evidence does not indicate, in this case, the evidence does not indicate that if the suspension were lifted, Camelot UK's business would be destroyed. Its business is limited to the operation of the third licence, which would be unaffected. On expiry of the third licence, Camelot UK has no ongoing business that could be said to be impacted by any unlawful failure to award it the new fourth licence. Now, there are, in our submission, a number of errors in that paragraph. It firstly leaves out of account a highly material factor, which is that Camelot's business is not limited to running the third licence. It extends to bidding for the fourth licence.
Yeah.
But secondly, and again, clearly we submit a legal error. Can I refer you to paragraph 34 of our skeleton argument?
Yeah, this is the test point.
Yes.
Yeah.
And the correct approach is in the italicised words in the middle of paragraph 34, taken from the judgment at 48.2. Would damages be an adequate remedy for the claimants if the suspension were lifted and they succeeded at trial? And then the adequacy of damages is predicated on an assumed finding by the court that the procurement was conducted unlawfully. Now, her finding that Camelot's business was limited to the third licence does not pursue that required approach. It assumes that the competition was lawfully conducted and that Camelot will only ever run the third licence. Number one, it's a short point, but on the correct approach, on the correct assumption that Camelot is successful at trial, what it has lost is the entirety of a business which consists of running off the third licence, operating the fourth licence, and indeed bidding for the fifth licence.
Yeah.
So that, we say, is a clear error in distinguishing the Lyons principle, and it's an error which is repeated further down in paragraph 92, in the second sentence, she repeats that Camelot's sole purpose as a corporate entity is to operate the National Lottery under the third licence. And just to be clear, this isn't, we say, a question of quantification. We can't quantify what Camelot has lost. It is simply the loss of an entire business. If you lose a contract and the business continues, then a payment of damages can replace your profits, and the claimant is back in the position it would have been in. But if the entire business is lost, it's not a matter of quantification, that is simply irreparable. Now, should the position be any different in the procurement context, and the Commission said, well, Camelot was an SPV, it went into this with its eyes open, it always knew what would happen at the end of third, or what could happen at the end of third licence. Well, we say in principle it can't make any difference. If a business is, if the lifting of a suspension or the failure to grant an injunction would destroy a business, causing irreparable harm, it should make no difference precisely why that is the case, what the circumstances are which have led to that, or indeed if that is a matter which ought to have been foreseen. Now, if there is to be an exception in the procurement context and SPVs and so forth, if there is to be an exception to the Lyons principle, then it will have to be for this court, or indeed another court, to establish it. It hasn't appeared in the case law so far. And any exception, we say, would really not extend, or ought not to extend, to this kind of case. Camelot is not a tiny subsidiary in a large corporate group which has been set up for a particular contract. Essentially, it is very largely the group, and it can't be replaced. Now, we then have a ground on adequacy of damages for Camelot Global, which is focused on the loss of reputation point, to use the procurement shorthand. So if Camelot UK does not run the National Lottery in the future, Camelot Global will be unable to rely on that in securing other work around the world in the way that it has done in the past. Well, Lord, I'm going to leave that ground to Mr. Moser, because he has a very similar ground in relation to IGT, and he will explain the points of principle which arise on the judge's approach, which was essentially the same between Camelot Global and IGT. On adequacy of damages for the Commission, which is our ground too, I'm again going to leave that in large part to Mr. Moser.
Yeah.
But we take a point which IGT doesn't take quite so clearly in paragraphs 50 to 54 of our skeleton argument. And perhaps if I could ask you to look momentarily at paragraph 121 of the judgment, which is the judge's.
Which paragraph of the skeleton were you
I'm sorry, I'm going to paragraphs 50 to 54 of the skeleton. And
yes, this is your public interest point and the potential, what you call asymmetrical treatment.
yes.
Yeah.
So there are two issues really. The first issue is, should the court simply read across public interest considerations which would be evaluated under balance of convenience into adequacy of damages for the defendant, and essentially say, as the judge reasoned here, there are public interest reasons why we ought to get on with the fourth licence, and that means that damages are inadequate for the defendant. we say that leads to confusion and a difference of approach. Confusion as between adequacy and balance, and a difference of approach as between claimants and defendants, and that's the asymmetric point, because under the balance of convenience, when the public interest is considered, the court is doing it on two different scenarios, two different assumptions. It doesn't prejudge who's right and who's wrong about these public interest matters. But when it comes to adequacy of damages, the judge's approach was, as we say, asymmetric, and simply accepted the Commission's own view of its public interest mission. But that's paragraphs 50 to 54 of our skeleton argument. And Mr. Moser will address that ground as well. So can I then move on to balance of convenience?
Yep.
Please. And we say that if you are with us that there is an arguable grounds of appeal on adequacy of damages for Camelot, then we say it must follow that there is also an arguable ground of appeal at the balance of convenience stage. Now, the reason I say that is 153 to 154 of the judgment, please, which is the...
Which of your grounds under balance of convenience is this? 1, 2, or 3?
So this will, I think, be ground 3. I'm taking it slightly out of order.
No, that's fine. I don't mind about that. I'm just for this purpose. All right. So you say if arguably wrong about damages, then also arguably wrong about what?
Balance of convenience. Because
in that, yeah.
In 153 to 154, you have the culmination of the judge's reasoning and the balancing exercise that she conducted. 153 is what she puts on the Commission's side of the scales, the factors in favour of lifting the suspension. And 154 is the other side of the scales, in favour of maintaining the suspension.
The more interesting question, though, is because if you're right that there was an error at the earlier stage, then you get permission to appeal anyway. That's what you'd say. You start and you say adequacy of damages for your client, the judge was wrong. You'd say permission to appeal should be granted. The more interesting question is, assume the judge was right at the earlier stage, did she then go wrong at the balance of convenience stage? Do you say she did or didn't? If you're wrong on your first ground.
If I'm wrong on my first ground, then I accept that the balance of convenience is
right. So it turns on it. So we're actually really looking at the first 2 points you've made.
Well, you are except that if I'm right, if you accept an arguable ground on the first on adequacy, the Commission still says that doesn't matter because she did an impeccable job on balance of convenience anyway. So
right. Okay.
bound to lose.
Yeah, so this is your counter to the point that says effectively you have to show the judge was wrong on both in order to get permission to appeal, and you say, well, this point leaches from one to the other in any event. So if you're right under one head, you're right under the other head.
That's right.
Understand that. Okay.
And the reason why it leaches is 154 is that the only factor which the judge placed in the scales on our side was the commercial losses that might be suffered by Camelot and IGT, for which damages would be an adequate remedy.
Yeah.
Now, there's a further point, which is that customarily, where a judge has ruled, as this judge did, that damages are adequate, and C 113, that is sufficient to dispose of the application. But I'm going to carry on for completeness to look at balance of convenience. where a judge has adopted that approach, the balance of convenience stage must be conducted on the assumed basis that the judge is wrong about adequacy of damages. And it must be conducted on that basis because otherwise there's simply no point in a balance of convenience analysis, in that what the court is doing, as is well established, is deciding which course, C154, will produce the least risk of injustice. But of course, if you're analysing it on the basis that damages are adequate for the claimant, then there's no risk of injustice to the claimant. End of. So we submit a very strange approach by the judge to go on to consider balance of convenience, but then to do it on the footing that she was right about adequacy of damages. Now, going back to part 1 of ground 3, which is the public interest in a determination of the lawfulness of the appointment before the award takes place. Before the judge, Camelot's case on the balance of convenience was focused on the national significance of this particular contract, just as I started my submissions today, which we said entails that ensuring a lawful appointment of the fourth licensee, which can credibly deliver on its commitments to raise money for good causes, is a matter of national significance. Now, that was not, as is very often in these cases, and as my Lord will have heard in many cases, simply an abstract point based on the desirability of ensuring compliance with the law, or a point of principle that the remedy of review is preferable to the remedy of damages. That wasn't it at all. The submission was tied to the wholly exceptional character of this particular contract. Now, we of course looked in the authorities for previous similar cases, and the only remotely analogous case in terms of national significance of a procurement is Edenred, with which my Lord will be familiar, which is at tab 7 of the authorities bundle. And this concerned a contract to operate, see paragraph 1 on page 189, I'm sorry, paragraph 2 on 189, a new scheme called tax-free childcare, for which 1.9 million families would be eligible, see paragraph 22. And the key factor for Mr. Justice Leggett, as he then was this, in maintaining the suspension, was the great significance of the contract, and so the heightened public interest of ensuring that the new scheme was implemented in a lawful way, and that's essentially paragraph 31 sums it up. That's the only remotely analogous case, suspension maintained. This case, we say, is a stronger case than Edenred for a determination prior to appointment because of the Commission's overriding statutory duties. And those were set out in paragraph 13 of the judgment. You'll have seen them in our skeleton argument as well. And you have in particular, see paragraph 13 of the judgment, section 4.1a, the duty to ensure that the national lottery is run and promoted with all due propriety, and then subsection 2 over the page, the duty to do their best to ensure that the net proceeds of the lottery are as great as possible. Now, lifting the suspension and permitting an award to Allwyn risks a situation where the National Lottery is operated by an entity which has been unlawfully appointed. Risks that. Contrary, we said, to the due propriety duty, and it also risks substantial awards of damages to Camelot and IGT from funds otherwise available to good causes, contrary to the subsection 2 duty of ensuring that the net proceeds of the lottery are as great as possible. Now, these are not typical public law duties, these are specific duties which are implicated in the question of whether there should be a lawful appointment or whether the court should ensure a lawful appointment or not.
Mr. Cobble, I understand that submission completely. Might it not be said, though, that a difficulty with it is that by feeding back in the question of risk, you are feeding back in the merits of the underlying challenge, which has already been paid in, as it were, and ticked off under the first heading, which isn't in dispute, namely the serious issue to be tried.
Well, that is the point. That's the key question. That is what the judge decided. See 128. Judgment 128. The judge said at the end of the paragraph, the last two sentences, the parties agree that the challenge raised is a serious issue to be tried. The dispute can only be resolved at trial, therefore does not assist in determining where the balance of convenience lies. So that's the culmination of her reasoning on our arguments on public interest in appointment. Now that we say is plainly wrong.
Because?
Now the reason it is plainly wrong is because, as my lord is well aware, what the court is concerned with on the balance of convenience analysis is weighing up two alternative scenarios and deciding where the least risk of prejudice lies. On one side of the scales, what irremediable prejudice would be caused if the suspension was maintained but the commission was successful at trial? On the other side of the scales, what irremediable prejudice would be caused if the suspension was lifted but Camelot was successful at trial? Now, all of these arguments on the public interest in a lawful appointment and the statutory duties and it's a nationally significant contract, all of that goes to the irremediable prejudice which would be caused if the suspension is lifted and Camelot turns out to be right, that Allwyn has been unlawfully appointed. So you're not predetermining the issues for trial, you're simply weighing in the wholly conventional way one side of the scales against the other. And on our side of the scales, what are the consequences, what's the prejudice that would be caused if the suspension is lifted and we are proved right at trial? That's where all of these public interest in lawful appointment matters fall to be considered. And it's simply wrong, it's plainly wrong to say I can't take them into account at all because it's an issue for trial. If that were right, then Mr. Justice Leggett was barking up completely the wrong tree as a matter of law. And my lord, I
suppose it might depend the extent to which you get into, in that sense, in this case, the criticisms of the Allwyn bid. So your answer to the judge's point is to say, well, if you're comparing the two cases, if the suspension is lifted and then Camelot win, the second of your two alternatives, when you do that, you say you have to look at, if Camelot win, that assumes that the all-win bid was not properly assessed.
Yes.
And you're not putting it higher than that.
If we win a trial, we will have established that the operator of the fourth licence has been unlawfully appointed, that the Commission unlawfully assessed the risk which its bid posed in terms of meeting good causes commitments. And
Well,
so
it might be that. I mean, that's one element of it, but there are, as I understand it, there are other more prosaic elements to the challenge, to the assessment. So you might be successful on those.
Well, my lord, they all, or almost all, I perhaps won't put it higher than almost all, but they almost all focus on the credibility of Allwyn's business plan proposals.
Okay.
If we win trial, we will have established that the Commission wrongly assessed credibility, has appointed an operator for this nationally significant contract who unlawfully, we would say contrary to its statutory duties, and now has to pay many hundreds of millions of pounds out of good causes. That is all serious detriment to the public interest that at least must be weighed. It's simply getting the ballot, getting the factors in the right side of the scales. It has to be weighed, it can't be dismissed. The final point that I wanted to address very quickly is that of interim licence, which is our part 2 of ground 3. Now, the parties are all agreed that whatever happens in relation to transition between the licences, there should be no gap in provision of the lottery. Can't countenance that. And Camelot's proposed solution to this potential problem, if Allwyn needs longer than the 31st of January 2024, the end of the third licence, Camelot's proposed solution was a new licence to bridge the gap between the end of the third licence and the start of the fourth licence if the fourth licence is delayed. We call it an interim licence, short-term licence, whatever. And it's common in, as my lord will know, it's common in cases such as this for the authority, if a suspension is maintained, for the authority to make interim arrangements. It might extend an existing contract. Here, the third licence can't be extended because it's come up against its 15 years, so you need a new licence, and you need a new licence pursuant to Section 5 of the Act, which is on page 3 of tab 1 of the authorities bundle. And Section 5.1, the Commission may by licence authorise a person to run the National Lottery. 5.3 shall not grant the licence unless an application in writing has been made. And Section 7, a licence granted under Section 5 shall not exceed 15 years. Now, the judge held, paragraph 145, that an interim licence was not an available option, that the delay in implementation, any delay in implementation could not be addressed by the grant of an interim licence. And can I ask you to look at 145, please?
Yeah.
And I'll start with her second reason. Under the National Lottery Act, so 3 lines in, the Commission does not have power to extend the third licence for a further period. As Ms Hannaford and Ms Davies submit, there is a risk that the direct award of an interim licence to Camelot would be found to be unlawful as an effective extension of the existing licence without any procurement exercise, which would be in breach of the 15-year long stop. Pausing there, that is with respect to the judge plainly wrong. The new licence under Section 5 would be just that, a new licence. Just as if we were awarded the fourth licence, it would be a new licence, and it has a 15-year term, or an up to 15-year term.
To be fair, the judge said there's a risk there.
Well,
She wasn't making any definitive findings. It was simply a factor she was taking into account.
well,
It would be an odd thing if this procurement challenge turned on whether an interim licence was or was not lawful. She's looking at whether or not it's a viable option, what the risks are. Surely that's not unreasonable.
well, for it to be a relevant factor in her considerations, there must at least be a material risk, not a wholly theoretical risk. But this is a wholly theoretical risk. This is a new licence. This would be a new licence with a new term. Simply don't understand.
I'm sure you'll be able to find a procurement lawyer who would challenge it.
Well, my lord, the reason why...
They indeed say that they had a reasonably arguable prospect of success.
Well, the reason why you wouldn't find a procurement lawyer who would argue it is because the only operator who could perform a new short-term licence is Camelot. That's common ground. Nobody else.
That may give rise to a QED as to why it's not an appropriate option.
But no, that this is important because the CCR, as all the procurement regulations do, don't have an exception to competition if there's only one operator who can do it. It's common ground. Nobody else is going to spend the time and money on an 18-month transition to perform a 6-month contract or whatever it will be. So the CCR were not a material risk either. So that's our ground. 3-2. My lord, those are my submissions, unless I can assist further. I should say I had arranged with Mr. Moser that I would.
Yes, no, that's very. I mean, I noticed the overlap, and you've deferred to Mr. Moser on the ones that I had noted were pretty pure overlap, so it's completely understandable. Yes, thank you very much, Mr. Koppel. Mr. Moser.
My lord, if I may start with an erratum that I spotted in our skeleton argument.
This is presumably in addition to the erratum that every single page in every single one of these bundles is stamped contains confidential information, which is untrue, because that's even stamped on every page of the judgment, which is available on Bailey to anybody.
And I noticed
we need to get over ourselves in procurement law in relation to confidential information.
My lord, indeed, I noticed it was also stamped on the index.
Yeah, absolutely. Vital. Nobody can see that. Surprised the index wasn't redacted. You noticed an erratum. Sorry, go on.
Everything that I say will be non-confidential. At page 35 of our bundle, but at any rate, at page 10 of our skeleton argument, which is paragraph 31C, which is within our ground 3, that's the interim licence ground, we say it was set out in the uncontroverted evidence, that's at little c, page 10 of our skeleton, of Mr. Hordenby, that Camelot and IGT are willing to enter into such a licence with no concrete suggestion of any inability to agree terms, etc. Against that evidence, it says here, Camelot UK, through counsel, merely raised the possibility. Camelot UK should read the Gambling Commission.
Yes. Yeah.
So with that erratum, I agree.
And that goes back to the point that Mr. Koppel was just making submission.
Yes, that's right. But the statutory condition is that there is an agreement on the terms, and the evidence before the judge, we say, was clear that Camelot, and indeed IGT, I should add, were willing to enter into a licence, and there should be no difficulty with terms. So, my lords, that was my learned friend's ground 3, similar to our ground 3. The other grounds, our grounds 4 and 5, I submit have also been, in essence, covered by the points made by my learned friend.
Yes, for the point about the finding of unlawfulness before the contract entered into, and 5, your points about the balance of comedian.
And the public interest, yes.
And the public interest, yeah.
And so, my lords, I will leave that there alongside what we say in our skeleton argument.
Of course.
Those
I
grounds.
mean, everybody can take it that everything that's said in the skeleton argument has been read, understood, and taken into account. So the purpose of this morning is to identify any particular points, either emphasis or clarification, or anything arising out of somebody else's submissions.
My lord, yes. And the particular emphasis I'd like to make is going to be about our ground one, which is our adequacy of damages ground.
Yes.
And I will deal much more briefly with ground two, which is adequacy of damages for the Commission.
Yeah.
Our ground one concerns Mrs. Justice O'Farrell's findings at paragraphs 100 to 108 of the judgment. Those are the passages on the adequacy of damages in relation to IGT. And your lordships would have seen those. I needn't take your lordships through those again. In essence, they were concerned with IGT's loss of reputation if the fourth licence did not come its way, and in particular the way that that was used. And I'll show your lordships at 103 of the judgment. Mr. Harkin's evidence is there recited. The UK is recorded as a significant contributor within its 2021 financial statement as the third largest contributor to revenues. The UK provides a particularly special and unique opportunity. This is the evidence to showcase products and services. The fifth largest lottery in the world based on ticket sales. There's the adoption of technology, and your lordship will have understood that IGT is essentially the technological backbone of the lottery, and so these are the products that we operate and sell. Without involvement, international standing and goodwill would reduce, and that is then quoted in 104, and in particular the last two paragraphs extracted from Mr. Harkin's evidence at 104, much to the same effect. The UK Lottery is one of IGT's top 10 customers. The UK is the fifth largest lottery in the world, a leading operator, watched by all those top lotteries across the world. And by losing the business, our standing with those other lotteries will be damaged. And at 105, it is accepted by the judge, it is accepted that IGT would rely on the fourth licence, if awarded to Camelot, to enhance future bids for other contracts. But then it is said against us, that is mere assertion, no cogent evidence that IGT would lose future contracts without its subcontract to Camelot UK, and so the matter turns against us. And in her reasons for rejecting permission on this ground, the learned judge, that's in our appeal bundle, tab 4, paragraph 79, the learned judge held only that the legal principle was agreed by all counsel and that she had simply applied it to the facts of this case. And in their notes in opposition today, the Gambling Commission and Orwin take the same line. In our respectful submission, however, whilst all the parties took the principle from the relevant first instance authorities, the way the judge applied it, we say, was not open to her as a matter of law. We also say that in any event, this is an aspect that now falls to be examined and determined at appellate level to avoid inconsistencies at the first instance as to how this is applied. If we start, my lords, very briefly with the American cyanamide test as explained by the learned judge with respect correctly, she has that at paragraphs 47 and 48 of the judgment. 47, the applicable principles are set out in American cyanamide, and there's then reference to various other cases, including Olint, Covanta, and Alstom. And the relevant questions for the court are at 48. Little Roman 2 is, would damages be an adequate remedy for the claimants if the suspension were lifted and they succeeded at trial? Or, and this is perhaps the more modern way it's put in procurement cases, is it just in all the circumstances that the claimants should be confined to the remedy of damages. Also relevant, and again these matters leach across into other grounds, is little Roman 4 and the phrase where there is doubt. Where there is doubt as to the adequacy of damages, then the balance of convenience comes into play. And in our submission, there must have been at least doubt in the present case as to the adequacy of damages in relation to Camelot and IGT in this case, on the facts as found by the learned judge herself. The learned judge accepted that IGT would rely on the fourth licence. And we say that the question of reputational damages is therefore clearly engaged. The question of reputational damages finds its fons et origo in the judgment of Mr. Justice Stuart Smith, as he then was, in open view. That is conveniently cited in another case called Kellogg. They're both in the authorities bundle. I'll take it from Kellogg, if I may, which is at authorities bundle tab 18. Kellogg was a procurement of contract for various services to the police. At paragraph 74 of Kellogg, which is at page 431 of the bundle,
Yeah.
is the citation from Open View. I won't read it all out. It's well known. It's also reproduced at length in my learned friend Skeleton. The test or touchstone in cases where loss of reputation renders damages an inadequate remedy. Over the page at 432, I would draw particular attention to paragraph 39.2 of Mr. Justice Stuart Smith's judgment, little Roman 2, between the two hole punches. Apart from the burden of proof lying on the party, it has to be shown that there is at least a real prospect of loss, that would retrospectively be identifiable as being attributable to the loss of the contract at issue, but not recoverable in damages. And I add in parentheses, not recoverable in damages, because these sorts of reputational losses are very hard to assess and are remote. And that is then also applied in that case at 75 by Mrs. Justice Joanna Smith in that case. And so that is the state of the authorities, at least at first instance. At this level, my lords, the only authority that mentions this, quite briefly, but at least in our favour, is DWF, just worth maybe turning it up just in passing, at tab 8, the judgment of Sir Robin Jacob in that case, and at page 215 of the bundle, at paragraph 52, there's some discussion of what might have happened in relation to DWF if it won, a host of speculative questions. The last sentence on that page, moreover, there would be the loss to the firm of general damage to its insolvency department, not only loss of or damage to an established team, but also loss of reputation. This is quite impossible to quantify fairly. It's a straightforward point, my lords. That is the only Court of Appeal level mention of reputational damages.
Yes.
So what we say we take from that is what we have said in our skeleton argument at paragraph 21b. And that is in our bundle at page 30. Your lordships may have it separately. It's page 5 of the skeleton. Having cited some of the authority, we say at 21b, it is submitted accordingly that the correct starting point of the court should be that where there is a more than fanciful case, that the loss of the contract opportunity would have an adverse effect on reputation, the court should find that damages will not be adequate. We've said more than fanciful. We're using the language of the summary judgment jurisdiction. Real prospect is the wording in Open View. It's the same in my submission. And then we explain why there will clearly be a serious adverse effect on the findings as made by the judge. And we say, when they are extracted again in B, we say that on that basis, she should have found that there was a real prospect of unquantifiable loss. Why would IGT be relying on the fourth licence in such bids other than to win them? And the uncontroverted evidence of Mr. Harkin of IGT went into some detail as to the frequency and apparent success of IGT's reliance on the National Lottery as a promotional tool. The learned judge says, oh, well, there was no cogent evidence, but with respect to read cogent as requiring actual evidence of future loss of business is too high a threshold. In fact, the learned judge was further inconsistent in the test she applied, even between IGT and Camelot, because it will be seen in Camelot's case, the learned judge required compelling evidence. We say that is telling, and it indicates too strict an approach to what is required. Also, my lords, the judgment ignores the evidence, again, of how exceptional this contract is. My learned friend has already made those points. There are references, if one reads on in paragraph 105 of the judgment, where these findings are made, there are references to, oh, well, this is a small percentage of IGT's global turnover. But with respect, that is, again, an illustration of the flawed approach. The relative turnover within a large global organisation is irrelevant to reputation. One knows of many instances where companies operate highly prestigious contracts as loss leaders, for instance.
I think, Mr. Moser, you may need to move on to your ground 2 in the time.
My lord, yes. And your lordships, I will finish this very briefly by saying that you already have the points in the skeleton argument. It's also not consistent with the way that this was applied in other first instance authorities. And for instance, contrasting the correct approach of the same judge in Draeger, where it was found
that's
that
your inconsistency at first instance.
Yes, exactly.
I understand.
And so, but we say it's not just, well, the facts are different, so you find differently. It is the law that matters. And in Draeger, for instance, it was found that some fire brigades adjacent to London might be looking to London for what they procure. Well, if that's the case, if that was cogent evidence, then the same applies here in spades. The lottery world is watching, as explained by Mr. Harkin. And so, my lords, I will take the hint and move on to ground 2. Ground 2, very briefly, in addition to the point made by my learned friend, Mr. Coppell QC, about the confusion between balance of convenience and adequacy of damages, we make the short point that the learned judge failed in her assessment of the adequacy of damages for the Commission to take into account what we called the downside risk. And that's the real likelihood that there would be less money for good causes if the claimants are right, and if Allwyn's business plan completely overestimated the good cause's contribution in its bid and could not in fact deliver that high projected figure. In other words, the central dispute in the case. And that is similar to the point my learned friend made about his ground 3. And like Camelot, we say that such a balancing exercise is required at the adequacy of damages stage as well. The learned judge said, oh no, under Sysmex I can't look at this because it would prejudge the merits. And we said, no, that's a misunderstanding of Sysmex with respect. Sysmex says you don't have a mini trial once serious issue is conceded, and that's absolutely right. It doesn't mean that you then ignore in the balance what the consequences might be of each side.
The effect of your submissions, coupled with Mr. Coppell's submissions, is that it's open to the police potential criticism that the merits of the tender challenge come in at every stage. Serious issue to be tried. Then, if you're right on the adequacy of damage for the Commission in this case, and if Mr. Coppell is right on the balance of convenience, I mean, I understand that the arguments that is a potential consequence.
Yes, but I would respectfully rebut that by saying that's one doesn't need to go that far, because what we're saying is what you have to take into account is the effect if either side is right. What the learned judge did at this stage was she looked at the situation if they were right. So, but there'll be so much money for good causes. It's true, of course, to say that there will be more money for good causes whichever of these parties wins, whether it's Camelot or Allwyn, because that's the nature of the fourth licence. However, as we know, Allwyn says, well, there will be so much more under our bid, which is why they won. And in looking at this, the learned judge looked only at that upside, and my learned friend Lord Panic addressed what he called the upside risk. It might not be as much as that, but did not look at that upside risk, and also didn't look at what we call the downside risk, which is that not only might there not be as much, there might in fact be less than there is.
So it comes to this, you say she looked at it if the Commission had been right, effectively, but not if they'd been wrong.
My Lord, yes. And that is, it's the short point, and that's what it is. And there is a point to similar effect on their facts at paragraphs 57 and 59 of
Yeah.
Camelot skeleton.
Yeah.
And unless I can help your lordships further.
No, thank you very much, Mr. Moser. Yes, Miss Hannaford.
My lords, thank you very much. Can I just start with one or two introductory points? In our submission, and I'll take your lordships to this in a moment, there is no reasonable prospect of Camelot succeeding on appeal on its points on, or IGT, on the points on adequacy of damages or balance of convenience. They have to, on any view, succeed on adequacy of damages or the proposed appeal goes nowhere. And in my submission, they also have to succeed on the balance of convenience, given the judge's finding that there was such a strong public interest in placing the contract. And I'll come back to that. That's those paragraphs at paragraph 153 and 154 of the judgment.
Yeah.
So that's my first point. My second point is this. The principles applicable to these applications were agreed by the parties. They're set out in paragraphs 47, 48 and 126 of the judgment. The judge applied those agreed principles and took a perfectly orthodox approach to the law. That is the American cyanamide test, reputational loss, and the points that can be taken into account on the balance of convenience. There are no identifiable flaws. Balance of convenience is, of course, a question of discretion. The learned judge set out the facts and evaluated them. There's no error of law or identifiable flaw in her evaluation. There is still, as was canvassed at the outset of this hearing, an issue on the question of an undertaking. But your lordships have made comment on there will need to be a written undertaking. And in any event, I've agreed with Miss Davis to leave the question of an undertaking for her submissions rather than mine.
Because she's more directly involved in any event.
My lord, yes.
Yeah.
When you say balance of convenience is a discretion, I mean, the question is, if you like, what's the risk of greater injustice?
My lord,
It's an evaluation, isn't it?
It is an evaluation.
Rather than a discretion.
Looked at in terms of an appeal, I think your lordship is right. But she has to carry out, the judge has to carry out a balancing exercise within the judge's discretion. I think it's how one looks at it at first instance. But I suppose looking at it from the height of an appeal, it's an evaluative exercise. But in my submission, but it also involves finding on the facts. But in my submission, there wasn't an identifiable flaw. She adopted a perfectly orthodox approach to agreed principles of law and a perfectly orthodox and proper approach to the facts. They've been set out and summarised clearly in the judgment, and then she's reached her conclusions. Can I then move on to the question of compelling reason? If the claimants cannot get over the question of whether there's a real prospect of success, in our submission, the urgency is such that there is no good reason to test points of law, which in our submission are no more than academic. And there is also this point, the test...
You say no more than academic because of the procurement bill.
Well, my lord, one for reasons that I'll come on to, because they raise what they suggest are interesting points of law, for example, on reputational damage. I say they're wrong about that. But actually, when it comes down to it, the judge's conclusion on reputational damage was that it was mere assertion. Whatever my learned friend Mr. Moser might say about the test for reputational damage, it couldn't meet any test on her finding, her evaluation of the facts. But I was also going to say, your lordship preempts me, that it is academic or not a useful exercise for the Court of Appeal to undertake at this stage, given the procurement bill, which is currently going through Parliament, and in which the test for lifting an automatic suspension, as currently drafted, is different.
Well, we don't want to spend too long on it, but there's an awful lot of words in the new test, but all of the commentaries I've read so far, without exception, all say that in the commentators' views, that will come back to being something that is either the same or very similar to the test that the courts now endeavour to apply based on American cyanide.
Well, my lord, given the sinews that have been strained in order to make sure that that is not the case, I find that a rather surprising approach to take in commentary.
I mean, having looked at the smorgasbord of points we're supposed to take into account if the new bill becomes law, I have to say, my view was that there wasn't a huge amount of difference in the end. But anyway,
well, my lord,
there it is. I just think that there are some points that have never been clearly set out in relation to suspensions. And it may be the new bill is designed to try and do just that. But,
well, my lord, in my submission, I don't want to spend too much time on the new bill. It is supposed to be a watershed moment because we no longer have adequacy of damages as a threshold the way it is currently drafted, and the test is basically all around the public interest.
Yes.
My lord, who knows precisely what wording will be in place when it goes through. But at the moment, it does not say, as the current regulations say, that you have to treat the position as if there were no automatic suspension, i.e. you have to look at American cyanide.
Yeah. Okay, so that's...
my lord, I just wanted to deal as well, by way of opening, with my learned friend Mr. Coppell's jury points, which it seemed to me probably went to the question of compelling case for the appeal to be heard. In my submission, there is nothing so exceptional about this procurement that puts it in a different place from so many others that this court here, well, the first instance courts in this country here. So if I can just deal very quickly with a few of his points. He said, first of all, it's a wholly exceptional public procurement, and he said most cases the courts here are not significant. They're small, not very interesting procurements. That is not right, as your lordships will both be aware. There are many cases of very great significance that are heard by the courts, and in many of those cases, the suspension is not maintained, it is lifted. Perhaps one that is of interest is the Ulster and Eurostar case, the case about the supply of the trains for the Channel Tunnel, where the suspension was lifted. My learned friend's second point was the outcome could not have been closer. Again, that is not an unusual occurrence in procurement cases. He also had a point that the claim was of relatively limited scope. Well, relative is a relative concept. Obviously, the learned judge suggested 3 months, but as your lordship correctly pointed out, of course, that takes no account of appeals, and we haven't got anywhere near trial, and here we are already in the Court of Appeal. So one would not rule out that happening again. And the learned judge, yes, she did say it could be done within 3 months of giving judgment, but plainly that can't be the case now, because here we are. And also she did say she thought it would be a 3-week trial. So relative, as I say, is a relative concept. the liability, my learned friend also made a point about the liability on the commission if it lost, running to many millions, which would come from good causes. That isn't necessarily the case at all, and this was canvassed in front of the judge. It is up to the Secretary of State where the money comes from, but it certainly is not definitely the case that it will come from good causes. And the question of the outcome being known before the licence starts on the 1st of February, in my submission, rather misunderstands the contract, because this is a two-part contract. The enabling agreement, which allows transition to the fourth licence from the third licence, which results then in the placing of the fourth licence. They are a two-part contract because the parties can't get out of moving on to the licence just because they feel like it. So it isn't, in my submission, that is not a good point. The contract will be placed if and when the suspension is lifted, and that starts with the enabling agreement and moves on to the licence. My Lords, can I then move on to Camelot's grounds? I'm going to, as fast as I possibly can, because conscious that we only had 3 pages in writing, I'd like to deal as fast as I possibly can with the points raised by both Camelot
that's
and
fine.
IG2.
I should make it quite clear that obviously you had the conventional amount of page space for respondents, and of course you can make any additional points that you would like orally. That is, of course, only fair and proper. My view was that it would be a very good thing if I could make everybody provide submissions that were 3 pages long, because both your submissions and Miss Davis' submissions were a pleasure to read because they were so succinct. So you can, of course, waffle around the points for the next 25 minutes or so. And of course, if there are points that you haven't made, then it will be important for you to make them. But you shouldn't think that simply because the two of you only had 3 pages, that the points that you made haven't been fully taken on board.
My Lord, I'm very grateful, and of course I will attempt not to waffle around the points. So if I could start with Camelot's Ground 1, the adequacy of damages for first Camelot UK and secondly Camelot Global. Camelot UK, Camelot argues the judge was wrong in paragraph 88 because they say she considered the adequacy of damages on the incorrect premise that Camelot would not be awarded a licence, and if she considered on the right premise, damages would have been found to be inadequate because they say the business has been destroyed. And it says the business that would have been destroyed was the operation of the fourth licence. Now, in my submission, this ground is misconceived. First, the judge did not make the wrong assumption. That is clear throughout her judgment, but in particular from paragraph 79, where she starts consideration of adequacy of damages for Camelot, and she makes that precise point. That's at the beginning of the section in which she makes the point. So there is absolutely no doubt in my submission, it's the second line of paragraph 79, that she knew what she was looking at. So she didn't make the wrong assumption. And secondly, she, in my submission, was obviously right that the business would not be destroyed. Now, her starting point was that Camelot UK was set up as an SPV for the operation of the National Lottery. That's paragraph 85. As such, during the currency of the third licence, as she explains there, it was precluded from other revenue-generating activities apart from ancillary activities, which she found, and it was common ground, had been pursued on a very limited basis. And on expiry of the licence, its staff and assets were to be transferred to the new licensee, paragraph 85. She identified correctly the principle in the Lyons case, that's paragraph 86, but she pointed out that you had to look at the facts of the case. Now, in the Lyons case, the claimant's existing business was destroyed by an unlawful act, namely the picketing. Camelot's attempt to fit within the Lyons principle is, in my submission, wholly artificial. It does not have any existing business which would be impacted by the wrongful loss of this procurement. Its analysis is highly artificial and involves claiming that the business that has been destroyed is the very business and only the very business for which it was tendering. It can't say its existing business has been destroyed because that comes to an end at the end of the third licence.
Why not?
And it doesn't have any other business.
In paragraph 2 of your document, you make the submission that Camelot UK is a special purpose vehicle set up for the purpose of the third licence. I mean, that's not right, is it?
My lord, I regret that isn't quite right. It was set up for the purpose of the first licence.
Exactly, paragraph 17 of the judgment. Camelot UK was the holder of the first licence and the second licence and the third licence. Why isn't its business, arguably, during the pendency of any licence, also to apply for a succession? You know, the next licence. I mean, that's a business opportunity.
My lord, that's...
Which the company has. I mean, that's the point that's put against you. And it's said that the judge took an artificially narrow view of Camelot UK's business when she said it's only to run the third licence and not to, as it were, tender for the next one, which it had previously done twice.
My lord, the highest my learned friend, Mr. Coppell, puts his case is that its business included bidding for the fourth licence, but its business has not at any stage included operating the fourth licence.
Obviously.
So if one is looking at destruction of a business, in my submission, that is simply not this case, because during the currency of the first and second licence, its business was doing the first licence and the second licence. During the currency of the third licence, its business was only the third licence plus ancillary activities, but it didn't do very many of those. And that was all common ground in this paragraph 85. And yes, it may have been entitled and was indeed entitled to apply for the fourth licence, but that does not make the fourth licence, even when one properly looks at it from the point of view of if they had won, that doesn't make it an existing business that has been destroyed. That, in my submission, is an entirely circular argument, because doesn't it lead to this absurd situation that if you are a company, an SPV in this case, that have been set up to operate one contract, now this may be the third version of that contract, but one contract, you can always say that your business has been destroyed if you've lost the next contract. But it's incredibly artificial and hypothetical in my submission. And it also involves saying you can't be compensated.
Yeah, I mean, in a sense, I think the argument is that the way you just described it, as it were, predisposes or sets the answer. Because if you say this company was only set up to operate a license, i.e. the one that it is immediately granted, then in a sense you've defined the fact in the way that leads to the result. If you say this company is set up to run a lottery in the UK, subject to whatever license is granted to it, part of its business is to tender for the next license, and its business will be brought to an end if it doesn't get it.
But my lord,
that's the argument. I mean, this is the argument. The question is, as I understand it, for the purpose of permission to appeal, whether it's manifest that the judge adopted the right approach on the facts as she set them out in paragraph 88. I mean, Mr. Coppell, Mr. Jose, particularly Mr. Coppell anyway, says no, she didn't.
well,
She made a mistake in the middle of it.
my lord,
On the facts. I mean, the question is that argument with a reasonable prospect of success?
my lord, in my submission, she didn't make a mistake, because the facts are those in paragraph 85, which is that it is a special purpose business. It's under the terms of the third licence, it can only do the third licence.
Well, she doesn't say it's incorporated as a special purpose entity for the operation of the third licence.
No, but the second sentence, no, my lord. The second sentence says, under the terms of the third licence, it's precluded from undertaking other revenue-generating activity.
Oh, absolutely, but as indeed was the case under the second licence and the first licence. But I mean, it doesn't mean, by definition, it doesn't mean that it was prohibited from bidding for the second licence when it held the first one, or prevented from bidding for the third licence when it held the second one.
Well, my lord, no. And in my submission, that is the height of my learned friend's case, that he says he was entitled to bid for the fourth licence. But that doesn't mean that a business is destroyed, or, to look at it another way, that Camelot can't be adequately compensated in damages for the loss of a future licence. Because the assets and staff and so on would be transferred at the end of the third licence. If there was no fourth licence, they'd just be transferred. The third licence, as set out in paragraph 85, and as I say, it's common ground, means that on expiry, that's what happens. So it's not like, and let's not forget, it is a company in a group of companies. So it isn't a business which has already got a functioning business but happens to run the National Lottery and says, well, if I lose this contract, that's the end for me, because that's a major plank of my business, and therefore I'm going to lose everything I'll have to give up. This is a one horse, one contract at the moment, one contract company. It can't do anything else, and it isn't doing anything else apart from these limited ancillary activities. And the fact that it has an opportunity to bid for another contract in the future, in my submission, doesn't mean its business is destroyed. Because if it did, every company in this position would be able to say damages aren't an adequate remedy for me. And in my submission, that would make a mockery of the first limb of American Cyanamid. My learned friend, Lord Justice Coulson, asked if there were other cases dealing with this. And the case that was referred to in our submissions is the Aircom case, which is in paragraph 13 of the authorities bundle, which again was about an SPV. And the relevant paragraphs are 25, 26 and 29.
So and give the paragraph numbers again.
I'm so sorry, 25, 26 and 29. So at 25, which is on page 306 of the bundle, the learned judge said the plaintiff, the incumbent supplier for much of the services to be offered under the new contract, complains that damages are not an adequate remedy because the loss of this contract will mean its Northern Ireland business will have to be wound up. And then, I mean, there are various issues on the facts, but at 29.3, well, 29.2, I've recorded the plaintiff is part of a group of companies with a turnover well in excess of £1 billion. If those in control of the group want to compete with BT, they have adequate resources at their disposal to do so either now or in the future. 3, if a large successful commercial organisation was able to claim successfully that because one of its offshoots might go out of business if it failed to win a tender, and therefore the award of that contract should be suspended, it would allow such an organisation to game the system. All such organisations would place their bids through small companies, which they could then claim would be wiped out if it was proposed that the next procurement exercise to award the tender to another competitor, and thus sabotage the prompt award of these types of contracts.
But this is factually different, isn't it? At least arguably so. This is not an SPV, the plaintiff. It may be part of a group, but it's not an SPV, and it's not required to be a special purpose vehicle by the contract which it was losing. Whereas, in contrast, the National Lottery does require the holder of the licence to agree to do nothing other than run the lottery.
Well,
and I say the lottery, and I'm using that in its general terms, in the way that the judge used it at the beginning of paragraph 85.
Well, my lord, in Aircom, it's a company that was set up just to do the Northern Ireland business, and it loses the follow-on contract, and it says, its business is destroyed, and the judge concludes that that would lead to a rather rum outcome. See paragraph 29(3). So in my submission, it is a very, very similar situation to the one we have here. But in my submission, it is entirely artificial in a case such as this to say that there is destruction of a business. The Lyons case was not about this sort of matter. It wasn't about whether, if you have one contract and you then tender for the next contract and you don't get it, whether that amounts to destruction of your business. There's no principle coming from Lyons that says that that is right. And in my submission, the judge was obviously right to conclude that its business was not destroyed.
On this related point, you haven't referred to paragraph 88 of the judgment.
Possibly, my lord, because I've lost the judgment. Sorry.
I didn't find the last sentence of that paragraph entirely straightforward. On expiry of the third licence, Camelot UK has no ongoing business that could be said to be impacted by any unlawful failure to award it the new fourth licence. But if that is taking into account the fact that there was an unlawful failure to award them the fourth licence, i.e. they should have awarded them the fourth licence, surely there would have been an impact on the business.
Well, my lord, but that involves, in my submission, artificially saying, well, they've got a business. But all that they're actually losing is the contract that they would get.
Not, yes, but if they'd been deprived unlawfully of the fourth licence, then that would clearly have a major impact on their business at the time, as she puts it, on the expiry of the third licence, because they'd have got the fourth licence.
But, my lord, yes, but that is not an existing business on which there is an impact. That is the new contract, and that, as she says in 92, any losses are readily quantifiable in damages.
But the I mean, we've got to be careful not to get too deeply into actually arguing this. But nobody suggested during this procurement process that Camelot UK was acting outside its legitimate business when it bid for the fourth licence. Nobody said you can't do that. Your business is limited to running the third licence. You're the one person in this country that can't bid for the fourth licence. It's not part of your business. Everybody plainly accepted they could.
My lord, yes.
And so, to take my lord's point, if they are unlawfully deprived of the success, what would on this hypothesis be the successful outcome of their business, namely the tender, the bid for the fourth licence, why cannot they say our business has now been destroyed?
Well, my lord, the other way of looking at that in my submission is, can it be compensated in damages? And given that at the end of the third licence they have to hand over, the fourth licence, something that has not happened, can of course be adequately compensated in damages because they can get the loss of profit and any other loss flowing. And that, in my submission, is what she's saying in paragraph 92. So she is taking into account the loss of it, but the question is whether the Camelot can put itself into the position of the Lyons claimant.
Yeah, I mean, do you say the judge was right in the second sentence of paragraph 92?
Well, my lord, yes, it doesn't have any ongoing business. Part of what it was entitled to do was to bid for the fourth licence, but then its loss of the fourth licence, when it shouldn't have done, can be compensated in damages. It isn't a case such as where you're being picketed and your existing business is being torn apart. It is, which is the Lyons case. This is simply a financially compensatable event.
But somebody could have turned around in the Lyons case and said, okay, your business has been put an end to, but we'll just quantify what it would have brought you over the next X years, and we'll do a cash flow and we'll discount it back, etc. So look, it's quantifiable. So why do we care?
Well,
to which the answer is it really that there's a second way that this test is often put, which is it unjust to confine you to a remedy of damages? The argument is, this is just a question of arguability, this is a question of reasonable prospect. Did the judge obviously get it right? The argument, as I understand it, is that where you actually destroy somebody's business, it's unjust to say to them, because we can project forward what you would have got over an infinite number of years discounted on a cash flow basis, that's tough. You've had your business destroyed, just take the money and go.
my lord, yes, but this is talking, in my submission, not about an existing business which is being destroyed, but a potential future business which can be compensated in damages.
Okay. So, I was just picking up you on your point. I was only just trying to test with you. I think you said there's two ways the judge looked at it. One is the business, and then the second is quantifiable. So I'm just testing whether...
Well, my lord, yes. I think what I'm saying on destruction is a big word for actual harm to something existing. And that is what happened in Lyons. That is not what happened here. And if you look at it the other way round, then what happened here, which is the loss of a future contract, is of course compensatable in damages. In my submission, that's what the judge has rightly said at 92. So in my submission, this is simply and obviously not a Lyons situation. And I test it by saying, well, wouldn't that be rather absurd? Which is what the judge in Aircom said as well. You all set yourselves up as a one-contract company, and then you say, oh no, my business is destroyed because I've lost the next contract. And in a situation where a number of bidders were bidding, who all, let's say there were two incumbents and it was being joined together in the next contract, they could both say, well, we had the third licence, half each, now it's being joined together in the fourth licence. We both lost it. Both our businesses are destroyed. So adequate damages are not adequate for either of us. In my submission, when you test it like that, it looks a bit absurd. And the judge's conclusion in my submission is obviously right. My lord, I seem to have spent almost all my time on point one.
That is an important, from Mr. Coppell's submissions, that is possibly the most important of the ground, certainly in relation to damages being an adequate remedy. I think some of these you can take very quickly.
My lord, yes. Can I just try to take some of the other issues quickly? So Camelot Global, this is about loss of reputation. There's no challenge to paragraph 93 of the judgment, where the judge stated that the loss to Camelot Global of the anticipated supply contract could be quantifiable. And what they say about Camelot Global is that the judge wrongly allied Camelot Global with the group. And in my submission, there are 3 points to make about that. First, that is exactly how Camelot put its case. So if you look in Camelot's skeleton for the application to lift... And the reference to the Camelot brand. And the reference to the Camelot brand, paragraphs 51 to 54. And
we have read this kit, so...
My lord, yes. And then the Holdenby evidence on which that is based, that is paragraph 74 to 85 of Holdenby, which is page 392 to 395 of the supplemental bundle. Again, there are some mentions of Camelot Global, but many mentions of the group and other Camelot companies and so on. So that's the first point. That's how they put their case. The second point is the judge did consider the position of Camelot Global in her analysis. First of all, she referred to the Holdenby evidence on Camelot Global at paragraph 84. Secondly, paragraph 96, where she uses the same words, diminished ability, clearly refers back to the evidence that she summarised in paragraph 84. And thirdly, in paragraph 97, she refers to Camelot Global's annual report. And you can see that it's Camelot Global's annual report by referring to where she gets this from, which is Mr. Tanner 3, paragraph 70. So she deals with it. And third point is there's no suggestion it would have made any difference if the judge had only considered Camelot Global. So my submission at this point is completely academic. There's then the question of whether she considered the wrong test. It's quite clear in my submission that she was applying the test in Bombardier. That is a test of cogency. You can see that from paragraph 95 and paragraph 105.
This is the test in relation to reputation.
I'm so sorry, yes, it is the test in relation to reputation.
Yeah.
In my submission, she applied the right test. You read the judgment as the whole, particularly looking at the bookends on this point at 95 and 105, and that is clear. But in any event, she found, for both Camelot and IGT, that it was no good just arguing, or it was no good it being mere assertion. So it's paragraph 98 in relation to Camelot, where she said they simply argued, and paragraph 105 in relation to IGT, where she says, second line, mere assertion. It's quite plain that that doesn't get anywhere near any test. It's quite interesting in my submission that IGT, in their submissions on reputation, try and argue for a different test, which is more than merely fanciful. Now, my learned friend, Mr. Moser, tried to finesse that today into saying, well, that was the same as reasonable prospects. It's not. More than merely fanciful is a test that they have adopted in the light of her very clear findings that all they were doing was mere assertion and wasn't cogent evidence. So in my submission, this claim in relation to both Camelot Global and IGT goes nowhere. The judge correctly applied the test that was agreed by the parties, which was Bombardier paragraph 58. It's in the judgment, it's in the parties' submissions. That was the test that was agreed. She correctly applied it, and she decided they didn't get anywhere near. Mere assertion or simply arguing is what she says in 98 and 105. And then the next part of this argument in Camelot's submissions is that to say that the judge didn't consider the uniquely prestigious nature of the fourth licence. Well, that's simply wrong. She did. She recited Mr. Howeldenby's evidence on that point at paragraph 83, but her conclusions were at paragraph 96 and 97. And it was perfectly open to her to conclude that this was not a uniquely prestigious contract, to find that Camelot and IGT had involvement in other lotteries and a track record. This is simply, in my submission, a disagreement with the conclusions on reputation. The test, in my submission, is clear and was applied, and the facts were properly evaluated, and there's no room for an appeal. Ground 2, adequacy of damages for the Commission. Camelot make 2 points here. Wrong to assess damages by reference to benefits the Commission wished to bring about in the fourth licence, which Camelot says are public interest factors. And secondly, they say if public interest factors can be considered, they have to be considered in relation to Camelot 2, and that means considering the risk of Allwyn's bid not being any good. Now, whether public interest can be relevant to whether damages are adequate. In our submission, it is quite clear that the judge didn't make an error here. This is the judgment at 114 to 121. The impugned paragraph, I think, is 121. But the losses that she's talking about, well, it's paragraph 118 through to 121. The losses she's talking about are, depending on how one looks at it, either non-financial losses to the Commission, because they're the benefits of the licence, and she identifies the benefits in 118, or if one considers them to be part of the public interest, it is right and consistent with authority to take them into account in deciding whether damages are adequate for a public body which is non-profit making but has statutory purposes. And that is clear in our submission from Factortame, which is referred to in my learned friend Ms. Davis's note. That's tab 5 of the authorities bundle, and the relevant bit of the judgment is on page 673 of the bundle at the top of the page. Would it be useful to look at that, as your lordship's familiar with that? Well, I'm sure your lordships are familiar with it. But page 1, page 673 of the case, page 141 of the bundle, having recited on page 672 American cyanamide and how it works, at the top of 673, Lord Gough says, conversely, this is the end of the second line, an authority acting in the public interest cannot normally be protected by a remedy in damages because it will itself have suffered none. It follows that as a general rule, in cases of this kind involving the public interest, the problem cannot be solved at the first stage and will be necessary for the court to proceed to the second stage concerned with the balance of convenience. So in my submission, it's entirely consistent that with factor tame to say you can take into account the fact that they haven't suffered actual damage, but there is loss to the public interest. And, my Lord, that is the approach Your Lordship took in Sysmex, which is Authorities Bundle tab 10, at paragraph 62. Paragraph 62 is on page 257 of the bundle. And Your Lordship says there that some of the elements of the trust's losses, such as the savings, could be calculated in damages. But then you say you consider this overwhelming evidence that if the suspension is not lifted, it would have a significant and detrimental effect on patient and clinical care. That's emphatically not something which is capable of being compensated for in damages. And the same approach, but I'm not going to take Your Lordships to it, was taken in open view by Mr. Justice Stuart Smith, as he then was, which is the Authorities Bundle tab 9, and he considers on the adequacy of damages for the defendant the health and safety impact on the local population as a relevant factor. That's paragraph 64. In fact, he decides in that case that damages were an adequate remedy for the defendant, but he still took into account public interest factors on the way. Now, there is then the asymmetric case point taken by Camelot. They say, well, if you can take into account public interest factors for the defendant, you must be able to take them into account for the claimant. But the factor that they want to take into account for the claimant is what's called the downside risk of Olwyn's bid. In other words, Olwyn's bid, they say, isn't very good. And that is the whole subject of this challenge.
Yeah.
The judge, in my submission, quite rightly rejected this at paragraph 110 for a number of reasons. She gives 4 reasons in paragraph 110. And the first one is that the court is concerned with the adequacy of damages for a particular claimant, not the wider public interest, which is relevant at the balance of convenience stage. Now, that is not asymmetric. That is simply saying this particular element of the balance of convenience, i.e. whether Olwyn's bid was not a good bid, is not relevant to adequacy of damages for the claimant. That doesn't mean there might not, in some cases, be public interest factors which are relevant to adequacy of damages for the claimant, but that is a part of the wider public interest. In my submission, she is completely right to do that, was completely right to do that, but in any event, in line with the orthodox approach in the case law, when she comes to consider, at paragraph 128, the question of whether the lawfulness of the procurement is a factor in the public interest. And the lawfulness of the procurement in this case, of course, includes the question of whether Olwyn's bid was not any good. She says, well, that is a question for trial, and it doesn't therefore assist in determining where the balance of convenience lies.
So 110 seems to suggest that the wider public interest is relevant at the balance of convenience stage.
Yes.
But then this element of the wider public interest, she then says, isn't relevant at the balance of balance of convenience stage. So
well,
I put it to, I can't remember, Mr. Koppel or Mr. Moser, that it might be said they were seeking to rely on, quotes, the merits under each of the 3 stages. But conversely, it might be said that here the judge is recognising it could be relevant at the 3rd stage, but then when you get to the 3rd stage, says, no, that goes back to stage 1.
well, My Lord, yes. But in my submission, there's no inconsistency or difficulty with that, and that is the orthodox approach, because it is, of course, a public interest, compliance with procurement law, but the conventional approach, which is the approach taken by the judge in 128, is that it doesn't assist because it involves looking at the merits of the case, and that there is a lot of authority against, starting with American Cyanamid and indeed your Lordship's views in pronouncements, findings, that's the word I was looking for, in Sysmex.
Yes.
So,
But there are other cases which suggest that if there is a, like, is it Eden Red?
my Lord, there is Eden Red, yes, and that was going to be my next point. So this bleeds into ground 3, really, this point about the downside of Allwyn's bid and the question of how you take into account the public interest in carrying out a lawful procurement. My learned friends rely on Eden Red, but in my submission, Eden Red does not stand for any principle that the public interest in lawful procurement trumps everything else. And indeed, that is what your Lordship said very clearly and forthrightly in Sysmex, which is the Authorities Bundle tab 10, at paragraph 25.
Yeah.
So that's on page 250. Paragraph 25, 2/3 of the way down the page, there is clearly a public interest in the proper procurement of contracts of this sort. See, by the way, and see by way of example, you say, including Eden Red. And then your Lordship says, the latter might at face value be taken as meaning this public interest trumped everything else and would always justify the continuation of the suspension. I am in no doubt that that's not what the judge intended to say in his extempore judgment. And then your Lordship went on and referred to what Mr. Justice Stuart Smith had said in a couple of cases, which are Kent and Alston, which is to like effect. And also there is Open View, where the same point was made again by Mr. Justice Stuart Smith, which is tab 9, at paragraph 27. And he says in the last sentence of 27, I therefore respectfully suggest that Mr. Justice Legate's observation in Eden Red should not be adopted as a statement of general principle, providing a freestanding reason for maintaining automatic suspensions in all cases. And earlier on, he has said in paragraph 23, I think, that Eden Red was an unusual case. And of course, one should not forget that in Eden Red, the contract hadn't been tendered. A trial date, an expedited trial date, had already been fixed and was 4 weeks after the application to lift.
Yes.
The salutary lesson from Eden Red is, of course, by the time the case had finally been decided by the Supreme Court, I mean, no disrespect to the Supreme Court there, it was a year later. And that is, of course, the difficulty, as your Lordship indicated earlier, with saying you can get a trial on quickly, because if there are interesting points of law, that may not be the end of it. Can I then deal again on this point of ground 3 with overriding statutory duties, because Camelot relies on the Commission's statutory duties and says that that is a reason why the balance of convenience favours a decision prior to the contract being placed. In my submission, there is nothing unusual about the Commission's statutory duties. All bodies have statutory duties. For example, lots and lots of bodies, local authorities and so on, have best value obligations. They can be highly relevant, of course, to whether you've got the right tenderer winning the contract. But that doesn't mean that the balance of convenience favours keeping the suspension in place in all cases or in this case. Then other points are made about the deed of commitment. The judge rejected that, the argument on that at 136 to 137, and an expedited trial. My learned friend, Mr. Copper, relies on that. And of course, the judge said an expedited trial would be possible, but she still said, and this is the key point, that that would still cause delay. And that's paragraph 142 of her judgment, and that was the problem. That, my lords, brings me on to interim licence.
Yeah.
which is a part of ground 3 for
Yeah.
Camelot, and I think it's ground 4 for IGT.
Yes.
So the judge looked in the judgment.
It's ground 3.
Oh, I'm so sorry. It's ground 3 for
yeah,
IGT.
but it's the
as
same
well.
point. Yeah.
The same point. The danger was, 1, a gap, or 2, a delay between the third and the fourth licence. And Camelot put forward some mechanisms. The judge looked in the judgment at all 3 mechanisms, which the claimant relied on to bridge the gap, and she rejected them all at paragraphs 144 to 152. The only part of that decision challenged by the claimants is the interim licence. The decision is at paragraph 144 and 145.
Yeah.
And in my submission, there are no prospects of success in relation to this. The judge at paragraph 144 and 145 identified the risks. I'm so sorry, I seem to have lost the judgment.
Paragraph 144, 145.
144 and 145. She expressed a view, not a determinative decision about whether there would be a challenge or whether the licence would be unlawful, but she expressed a view that there was a risk,
Yeah.
having heard argument and, of course, evidence. So we were talking, she explains in paragraph 144, about an interim licence for 10 to 12 months. And then she makes 2 points. First, that it would be necessary to agree the terms. And secondly, that there was a risk of unlawfulness. Now, on agreement, my learned friends seem to say that we didn't say there was a problem with this. Now, that simply isn't right on the evidence. Mr. Holdenby came up with a timetable for discussions and negotiations about a interim licence, and that timetable is in the supplemental bundle tab 13, page 424, and that talks about a 2-week period for discussion of terms. Now that, contrary to what both Camelot and IGT say in their submissions, was replied to in Mr. Tanner's third statement at paragraphs 89 to 93. That's the supplemental bundle tab 17, page 494 and 495. Mr. Tanner explained there, and the judge was entitled to take into account, that the timescale was unrealistic and that, in fact, there would be complexities in agreeing a new interim licence. So it simply isn't right to say, as Camelot and IGT do, that this was perfectly straightforward. Mr. Tanner explained, and the judge was entitled to take into account, that it wasn't. They also then say, oh, well, if there's no agreement, the Commission could return to court and try and apply to lift the suspension again on new facts. But in my submission, that simply does not cover the question of delay. And one of the key factors for the judge was that there would be a delay, paragraph 142. So that's the question of need to agree the licence. So in my submission, there's plainly no error there. The next question is, was she right to say that there was a risk and that it wasn't reasonable? And in my submission, yes, she was right to say that. There are a number of potential challenges here. The first one is, would this be challengeable by way of judicial review on vires, etc. grounds, because this interim licence is simply a backdoor way of extending beyond the 15-year long stop. Common ground that the 15-year long stop runs out, and therefore there would need to be a new licence. And my learned friend says, oh, well, there can be no question of that being a problem. We can just have a new licence. And they say, and this is Mr. Holdenby's position in evidence, they say, well, it would be essentially on the same terms as the third licence. But in my submission, the judge was perfectly entitled to say there was a risk that could be considered by someone out there to be a breach of the 15-year long stop. And the second point is, of course, it could be said that there was a breach in procurement law terms. One only needs to look at the number of parties in this case and all the other cases that go through the court to say that a challenge is possible. My learned friend says, again, breezily, as he said to the learned judge, she says again today, well, it's obvious only Camelot could do it and no one would challenge. But, my lord, that is mere assertion. The learned judge was entitled to take on board risk. Not all parties who might apply to challenge on whatever basis are in front of the court. So in my submission, the judge was clearly right, and there's no identifiable error in those two paragraphs, or identifiable flaw, sorry, in those two paragraphs, which suggest that there are any reasonable prospects of appeal. My lord, those, can I just very quickly check that I've covered everything in relation to IGT?
Yes, because I think the last point goes back to the balancing exercise. Mr. Coppell says that the final point is that if he's right on his ground one, the one you've spent some time on, then that leaches through to the balance of convenience, because when the judge undertook that exercise at 154, she did it on the basis that damages would be an adequate remedy. If he was right that they wouldn't be, then she hasn't done the balancing exercise correctly.
Well, my lord, what I say in relation to that is, one, he doesn't have any prospects on ground one, and two, it is clear from 153 and 142 that what the judge was worried about was delay, and she says in 153 that the public interest is a strong factor in favour of lifting the suspension, and that's delay, and she says, as set out above, that's 142.
Yeah.
And she has formed the view that the delay cannot be sorted out by any of the three mechanisms, and the one that has been highlighted in the proposed appeal is the interim licence, and that's 144 and 145. So in my submission, the balancing exercise is not wrong, but those are my 2 points on that. One, no prospects on ground one, and two, this is actually about delay.
Okay.
And delay is not solved. I should perhaps just say, make it clear that on the interim licence, it has been submitted by Camelot and IGT that solves delay, but it can't on any view solve delay, because an interim licence is building in a delay of 10 to 12 months between the third and the fourth licence. It could solve, provided there are no challenges, it could solve the risk of a gap. But the learned judge quite rightly, and as she was entitled to, said that there was a risk in relation to challenges. Now, just running through one or 2 points that I have not mentioned in relation to IGT. IGT on ground one, I hope I've dealt with most of this, but...
Isn't this for Miss Davis? I'm with the greatest of respect, maybe...
maybe I better sit down.
Well, I mean, unless there's some... And I mean, I thought you were dealing with the points. You've dealt with everything as far as my checklist says.
My lord, yes. The one point I hadn't dealt with was DWF. Can I just very quickly mention DWF, which Mr. Moser mentioned? He says that that's an appellate authority on reputation. In my submission, that there isn't a point of principle in DWF in relation to reputation. It is simply a finding on the facts.
Well, yes, but it is the only appellate authority dealing with reputation that I recall.
My lord, that's right. But for the reasons I gave earlier, that is of academic interest because of the evaluative findings that the learned judge made, which was mere argument, simply argument and mere assertion. I apologise to your lordships and to my learned friend, Miss Davis.
No, that's all right.
Too long.
My lords, I obviously respectfully adopt and endorse all the submissions made by my learned friend, Miss Hannaford, as to why none of the proposed grounds of appeal demonstrate an arguable error of the nature that would justify permission to appeal being granted, particularly bearing in mind the time and the test. None of that's going to be improved by me adding to it. The one point I did just briefly want to address orally relates to the, in our submission, wholly unsatisfactory position, notwithstanding the debate this morning about cross-undertaking and damages.
Yeah.
And I want to address the broader implication of that in terms of whether permission to appeal should be granted at all. Because the debate, where, as I understood it, where we got to this morning, is both my learned friend Mr. Koppel and Mr. Moser indicated that if permission to appeal was granted and suspension was continued, some form of undertaking, as yet not clear, would be forthcoming, not clear from whom.
No, the position is the other way round. As
Right,
my lord, the position is that permission to appeal, if it were to be granted, would only be granted on condition that there was a satisfactory written undertaking as to damages. So if
and we wholly endorse that position. It won't come as any surprise.
Yes.
But there's another entirely troubling aspect of where we've got to in relation to this, which is, as the court is aware, in paragraph 125 of the judgment, the judge made clear that the suspension would only be maintained if unlimited cross-undertaking in damages were provided by Camelot, and she's there referring to Camelot UK and Camelot Global, and IGT. And we wrote to the parties on the 1st of July, asking them for confirmation that if their appeal succeeded, they would indeed provide the undertakings that the judge had in mind in paragraph 125. We have had no answer to that letter at all from either party.
Is the letter in the bundle?
Yes, it is in the bundle. It's in supplemental bundle at tab 32. It's the letter that we attached to our submissions, but it went into tab 32. At page 743.
So you better give me this one.
Seven.
743. Should be a letter of ours dated 1st of July.
Yeah.
And my lords will see that in paragraph 2 we pointed out what the learned judge had held in paragraph 125, and then said the position will be the same with your client ultimately to prevail before the Court of Appeal and any appeal against the order. If your clients would ultimately be unwilling or unable to provide such an undertaking, the appeal could have no utility. And we pointed out that they hadn't confirmed their willingness to do that, and we invited in paragraph 3 each of them to confirm urgently and by return that they will offer an undertaking in respect of losses incurred as a result of delay, A, pending final determination of the appeal, that's the debate that my lords had with my learned friends this morning, and B, pending final determination of the proceedings as a whole. And this is an important point, because if that undertaking is not going to be forthcoming, an appeal is purely hypothetical, because the suspension is not going to be maintained. And actually, all this debate is as to whether or not the Gambling Commission can, as it wishes to, enter into the contract with my clients, which of course my clients wish it to. An appeal...
Sorry, just so I'm clear, which undertaking is not given?
There's no confirmation that if permission to appeal is... Sorry, if the appeal is successful, they will provide the undertaking which the judge...
undertaking will have nothing to do with the appeal. The undertaking that must be provided is an unqualified undertaking as to damages if the challenge to the procurement is ultimately unsuccessful, however that point is reached.
Well, with my lord, if that undertaking is given, this point falls away. But with respect to what my learned friends this morning were talking about was only an undertaking for the as a result of loss caused by the stay of.
And I think I interrupted to say, indeed, I think my lord said, well, no, it's not it's not that. It's the wider point.
Well, my lord, if that is clear. And if
we shouldn't have to be refereeing in a courtroom of 50 lawyers,
well,
doubtless all of whom are claiming fees. We, the two of us, should not have to be policing and making these points plain.
My lord, we entirely agree. We wrote on the 1st of July. We wrote again earlier this week on the 12th of July. The letter, 11th of July. The letter is at page 752. We've had no answer to that either.
Yes.
This is the problem.
Well, in part, the answer, which was wrong, which was the letter written to me yesterday, saying none of this has an impact on the appeal. And as I pointed out 2.5 hours ago, that rather ignores the point that the whole purpose of the appeal is to maintain the suspension.
And that was that letter to which our letter of the 11th of July and the Gambling Commission's letter of the next day were a reply. We've had no responses to those either.
Yeah.
And this is a very significant point from our point of view. The detrimental consequences of permission to appeal being granted, which ultimately led nowhere, are significant. We are now in the minimum transition period for the clients. My clients, that started on the 1st of July. My Lord has indicated that if permission to appeal is granted, the hearing will be heard in September, possibly towards the end of September. Even if we got the result that day, or the second day of the hearing, that would mean we would have lost 3 months of the minimum transition period, 6 months of the period allowed under our bid. There's absolutely no question that that will have substantial consequences in terms of my client's ability to start the 4th National Lottery on the 1st of February. Of course, everything will be done to transition as quick a period as possible, but that's good. Even doing that will involve very substantial costs. There was a lot of evidence before the judge as to reducing the transition period, whether that would lead to only implementing part of the proposals, the impact on good causes of that. It's not just impact on my clients, therefore, because it could lead to a less quick improvement in the contributions to good causes and so on. Yeah. So this is all absolutely critical. And frankly, the fact that it wasn't until my Lord raised it with Mr. Coulson and Mr. Moser this morning that they even, on their feet, sought to offer an undertaking in relation to the effect of a stay, which isn't the broad undertaking that my Lord is referring to, is extraordinary. And really the point I wanted to make, and my Lord has it, is that absence proper undertakings covering the entirety of the losses in the event that the challenges are unsuccessful, then this court shouldn't even countenance granting permission to appeal. It is 2 minutes past 1.
No, that's very helpful, because I can tell you that my Lord and I did meet to discuss this yesterday, and the question of the undertakings arose early on in our discussions. Yes, all right. Any other?
Sorry, my learned friend Miss Hannaford, as I'm on my feet, has also asked me to just raise the point about whether the undertaking covers losses to good causes. It is undoubtedly the case, the reasons I've just expressed, that even a delay to September could lead to reductions in contribution to good causes.
Well, as I said to Mr. Coppell 2.5 hours ago, I'm a bit reluctant to get into points about the wording of proposed undertakings that have not been put in writing.
Well,
I'm doing my best for the parties, but there are limits. They have plenty of lawyers who could advise them as to that. It's not for me or my Lord until we see a draft, until we hear if it's not agreed, which I sincerely hope will not be the case, for us to comment on wording. And I make it clear, it's got to be the widest possible undertaking in terms of the consequences if the challenges are ultimately unsuccessful. And that is, Mr. Coppell referred earlier to the difference between this case and what might be called bog standard procurement challenges. In a bog standard procurement challenge, you have a written undertaking as to damages. So this case is different, but in that context, at any rate, it is an adverse difference to Camelot. All right, thank you very much. Okay, I think all the ground has been traversed. Mr. Coppell, with one exception, can I just give you the opportunity to deal with this? There's a small point in your various grounds, not one I think that you addressed orally, but I just want to be clear. There is, you raise a criticism that the judge was wrong to allied Camelot Global and Camelot. And the answer's put back, well, that's how it was presented. And the references to the Camelot brand taken from your submissions. Just on that point, that does appear to be how it was put. Is there anything further you want to say about that?
Yes, my lord. So we don't accept that that's a fair characterisation of the way that it was put. I do accept, of course, that the heading in the relevant section of our skeleton argument, which is at page 68 of the supplementary bundle, referred to was non-compensable damage to the Camelot brand.
Yeah.
But then when you go into the detail of what is said under that point, paragraph 51 on page 68 of the supplementary bundle refers to the role of Camelot Global in leveraging the Camelot brand outside the operation of the National Lottery. And the detailed points on the evidence are in paragraph 57 of the skeleton, which again is solely directed to Camelot Global. So whilst Mr. Hornby's evidence did of course cover other companies in the group, so far as damage to reputation is concerned, we were acutely conscious that the evidence had to be directed to Camelot Global, which is the company which has leveraged the brand in other ways, and that's reflected in the skeleton argument, paragraph 57 in particular.
Okay.
So well, we do say that's an unfair characterisation. It's surprising that the judge referred so often to the Camelot group rather than specifically to Camelot Global, and it does in our submission call into question whether she was focusing on the evidence.
Okay. All right. Well, that was the only point I had for you. Yes, all right.
Can I, while I've got the evidence bundle open, make just one other point by way of reply, but which I hope will be helpful on ground one. Just one other paragraph of the evidence on page 382 of the supplementary bundle.
Well, just give us the reference.
It's Mr. Holden B. First 51.1 on 382. Where he explains that Camelot had to seek permission from the Commission to bid for the fourth licence. The Commission granted permission as an ancillary activity to bid for the fourth licence. So the submissions that somehow the bidding for the fourth licence is not to be regarded as part of Camelot's business.
Okay.
Flies in the face of that.
All right. Thank you all very much. We will come back at 2:30, at which time we expect to be shown the agreed wide-ranging unqualified undertakings to which we have referred. All right, 2:30.
My lord, I just raise the possibility of a slight technical problem in that our clients are 6 hours behind us in the United States. But
They've been 6 hours behind you since March when the challenge was made.
My lord, yes.
2:30.
this is